I think there's circumstances. You got to feel it out. I mean, if she's like, if it seems like that, then you can believe that. But I don't know if just dinner first. Well, I don't know. They were at the bar though. Yeah, I'm gonna be quiet.
You might be digging yourself through a
Now,
hole.
okay, almost unanimous. Ms. Clements brings in the other fact that the other guy and the friend are supposed to show up also, but pretty much unanimous. He, in his mind, this is an indication, a very strong indication, that basically she wouldn't be coming back to my place if that's not what she wanted. Right? If I bought her dinner and she's coming back to my place, we're going to have sex. The women, if you have dinner with somebody and you say, okay, I'll go back to his place, what does that mean?
I want to see if he keeps his house clean and has a dog.
You want to see if he keeps his room?
You want to? This is an attempt to get more information.
Yeah, it's to talk maybe, but not.
To talk, Ms. Harper says.
I was going to say closing the wage gap.
I beg your pardon?
I was going to say closing the wage gap.
Yeah.
Closing the wage gap? That's why you went back to his apartment?
No, it was a food. Never mind.
Dinner party.
I would definitely say that does not mean you're consenting.
It does never.
Yeah.
Now.
Well, I was gonna just add to that, like, he just paid for all the dinners. I want to see this guy's apartment. What he does. And if it's clean.
Having gone to law school in New Haven, right near West Haven, it's probably good information you want, because you never know what you're going to get in the neighborhood in that area.
So, like, in my head, of course, that doesn't mean that I want to have sex, but I know that guys think that way. So I know that if I don't want to have sex, I'm not going to a guy's apartment. Like, well, granted that it was supposed to be in a group, but it's like, we know these things. Like, guys think that way, and it's not
Guys think that way, but women don't.
Right, but like,
And as a matter of fact, your behavior.
reasonable women know that guys think that way. I feel that.
So any woman who goes back to a guy's apartment is being unreasonable?
No, not that she's being unreasonable, but not having that in her mind that that's a possibility, that that's what he thinks is unreasonable.
I mean, I'm just going to be honest. I would not go back to a guy's place unless I wanted to be alone with him in some fashion.
Yeah.
Okay.
I mean, sometimes you're just being friendly and you want to continue the conversation. So, like, I don't think, like, going back to a guy's place doesn't, like, means that, like, stuff is going to happen. Or at least I don't think it that way. And, like, if things do get, like, too flirty, I'll be like, quit it. Like, I don't want this.
Okay.
Or, like, get myself out of that situation. But, like, I'm not going in.
I think that it's just as reasonable to say that while women know that men may think that going back to their place means that men think that something else is going to happen, it's just as reasonable to put that like on men to know that just because a girl's going back to the place doesn't mean that she wants to have sex either. Like,
Okay.
the expectations on both sides.
Good. Great discussion. And it illustrates a point we began with, or one of the points we began with, which was the difference between the way men and women perceive these interactions, right? With some dissents, a general trend here of agreement, of consensus, not unanimity, but consensus is that women may perceive the act of having dinner, allowing him to, or having him buy dinner and going back to his place doesn't mean you want to have sex, and women don't want men to make that assumption, but men do. Right? The difference between the way men and women perceive these things, and there's lots of reasons for that difference. Socialization, etc. Okay? All right, so she goes back to his apartment. What happens at Smith's apartment?
So they're sitting on the sofa, and he asked her to kiss him, and she did it once. And then he kind of got in her face and was like
explicit. She says, anyway, look, I am not kidding, I really don't want to do anything, right? So we have an explicit statement of non-consent, again, according to her testimony, okay? Does that lead him to back off?
No.
So whatever assumptions he might have come to the apartment with, let's say he did, and there's some of the testimony indicates he did, at this point, she has declared that those assumptions were wrong, and he still doesn't back off. And he says, you don't think I paid for dinner for nothing, do you? What did she try at that point?
She spits in his face and then tried kicking him off her, but it didn't work. Which he was 6'2" and 200 pounds, and she just couldn't get him off of her. And then he told her that she could make it like easy for herself or make it difficult for her, I guess, kind of threatening her, saying like, you can do this the easy way or the hard way. And she took that as a physical threat. So she stopped resisting when he was on top of her on the couch. And then she like said that she was good. Once she gave in, she was going to play along with him and pretend she like was enjoying whatever.
What does she say that Smith said after the intercourse?
That she enjoyed it.
But as part of that same statement?
The defendant said that he knew the victim felt that she was raped.
But she couldn't prove it, and she really enjoyed herself, right? There, I mean, that statement alone, I know you think you were raped, right? But you can't prove it. There's a smugness to that, like a sense of, I'm safe from anything you do, so don't even try. Don't even try. At least that's the way I'm gonna portray this as the prosecutor, right? Look at what he said to her, the mocking statement he makes to her, okay? And then he asks her for her number. And what does T do? What's wrong with this one?
She gives him an incorrect phone number.
She gives him a phony number. She's thinking, right? She has, and this is, every case is different, every person, every victim is different, but she is able to think and to come up with protective strategies. And she gives him a phony number. And then what did she do? Even more interestingly, and I think a very fascinating act on her part.
She puts a pink lighter under his sofa.
Why did she do that?
To prove later on that she was there at his apartment.
Because what does she anticipate when she does that, and she wants to be able to prove to the satisfaction of police or maybe a jury that she'd actually been there?
He's going to say that never happened.
It never happened. She was never there. Now that might have been a little bit unnecessary on her part, because there are probably going to be fingerprints, right? There's probably other ways to prove she was there, but maybe not. So it was a great precaution, right? And when the police get there, it was right where she said it would be, right? So prove she knew she had left it there. Now, if you look at the bottom of 949, the very bottom, the court first rejected the defendant's argument that the Connecticut statute contains a mens rea component or a reasonable mistake of fact defense. This we're going to sort of put off for the time being because it's not part of this case, but it is critical. It is a really important issue about this whole question of whether or not traditional mens rea requirements apply here, and whether the mistake of fact on consent is a defense, okay? But here we just have it in a bracket. If you're interested and want to look up State versus Smith, you can see the full opinion, including this discussion of this issue, okay? But we're going to postpone it for right now. So what does the court say is the role of consent relative to non-consent under the Connecticut law?
They said that the issue is to believe whether or not T's conduct under all given circumstances, if a reasonable person would believe that she
what is the legal structure of how we consider consent? How is it relevant, and how does it play out in the trial?
They said that the defendant is not, you cannot like penalize him for not knowing the internal knowledge.
You're moving past where I want to go. You're absolutely right, but I don't want to get there yet. I need more basics first. Mr. Weissman?
So if she doesn't like verbalize that, a reason.
Again, that's later.
But
That's-
okay,
more generally, what does the court say about consent?
It cannot be viewed as a wholly subjective concept.
Also past where I want to go. Nothing's wrong in anything you're saying, but I need something first, more basic, I guess.
They look at it like contracts? Is that what you mean?
Oh God, I don't want to talk. Contracts, you're pulling contracts on me. How does it work in a case? That is, how does it work in a case under this Connecticut statute? I'm sorry? Good. First of all, the court says consensual intercourse is, I mean, this may seem self-evident, but is no business of the criminal law. And so, taking that as a premise, the court says, well, if consensual intercourse is no business of the criminal law, then we have to say, how will it play out, whether it was or was not consensual? How does it play out? What does the court say?
The burden is on the state to prove lack of consent beyond a reasonable doubt.
Prosecution must prove non-consent beyond a reasonable doubt, because non-consent is an element of the offense. It could go the other way. We could say, let's say, for example, you could imagine a structure, and it exists in some places that require affirmative consent, whereas if the prosecution introduces just a prima facie case, some evidence of non-consent, right? There has to be at least some evidence to trigger this burden. You could, but the Connecticut court rejects this, you could require defendant to bear the burden of affirmatively showing consent. But the Connecticut Supreme Court says that's not it. That's not the law here. That X doesn't apply everywhere, as we'll see, right? Because you can go to a framework where affirmative consent must be shown, and if you can't show affirmative consent, the defendant loses. But that it's rejected here.
That's what the court meant when they said consent is not an affirmative defense.
That's right. Consent is not an affirmative defense. That's the same way. That's exactly the same as saying what I just said. Okay, consent is not an affirmative defense. Non-consent is an element of the prosecution's case to be proved beyond a reasonable doubt. Okay, so that's what I wanted to establish first. So how do we do this?
So they give it to the jury to determine whether a reasonable person would conclude from all the circumstances that the plaintiff, based on her behavior, was consenting to what was occurring.
What was that last part again?
That based on her behavior, she was consenting or not.
And so if you look on 950, the court says, if her conduct would reasonably be viewed as indicating consent to the act of intercourse, a defendant should not be found guilty because of some undisclosed mental reservation on the part of the complainant. And that's what I was getting at, leading to in our last case, in Barnes, right? If she had not given any indication, right? The court here sort of tackles that issue head on. It says if there is non-consent, but is not manifested, i.e. undisclosed to the defendant, defendant should not be convicted. The defendant should not be convicted. So if she take actions that actually would indicate consent to a reasonable person, that forecloses a guilty verdict. Now the court here doesn't believe that a jury would actually convict a defendant in a situation where it found as a factual matter that all the outward manifestations by the complainant were such the defendant was reasonably led to believe that the complainant consented. But the jury is also convinced, well, all that was what the defendant was led to believe, she didn't actually consent. She didn't actually consent. Maybe that her testimony is credible, maybe there's corroborative testimony of that, right? So in her own mind, she didn't consent, but there were no outward manifestations of that. So the court says, look, we don't think anyone would be convicted in that situation, but if the defendant is concerned that the jury might convict, then the defendant should ask for a jury instruction, saying that that there must have been a reasonable belief that she consented. So in this case, Ms. Rangaswamy, how does this all play out in this case?
So in the end, they concluded that, like, according to her uncontradicted testimony, she, like, expressly declined his advances, explaining she didn't know him and wanted to pick up her child. She spat in his face and tried kicking him off, and Linda gave in after he declared he couldn't make it hard for her, but she continued to resist. So they found him guilty.
T manifested non-consent. So this is not that the court sort of does all this speculating about a situation where the non-consent was not manifested, right? What would happen there? And then you have to have jury instructions, and the defendant has to be able to at least argue it to the jury that, hey, I didn't know, she didn't show with any signs that there was non-consent. Here, it was manifested. Right? The jury was entitled to believe, credit her testimony that she spat at him, she kicked at him, she verbally told him, big man, you have to force somebody. Right? There were plenty indications of her non-consent. So, and that's what tends to happen. Although this issue about manifested and non-manifested, did I believe I had consent, is a big issue in the law and a controversial one, the facts of these cases usually, overwhelmingly, have indications of non-consent, right? The question is, are they believed? And the jury can believe either side in a lot of these cases, but rarely is there really a situation, and the court says, look, we don't think this is going to happen, where there's really no evidence that the victim really didn't indicate in any way a lack of consent. There will be something, and then the question will be, which did the jury choose to believe? Mr. Webb, did I see your hand? Never mind.
So if we have all the same facts up until when they're watching TV, and he begins to touch her, and her normal reaction to that touching is to freeze. She doesn't consent, but she freezes, which we know is a normal reaction. He would be found not guilty because
he would at least be entitled to a jury instruction that the jury should not convict because she did not manifest consent. I'm not sure you get a directed verdict or a dismissal of the indictment because the prosecution would try to show that her reaction of freezing itself was a manifestation of non-consent. I mean, that's what I would try to argue. But those are the very rare circumstances when you do have the situation that non-consent is at least arguably perhaps not manifested. I mean, we've seen Barnes and we've seen this case where there was again, if the jury credits it, there was overwhelming evidence that the victim did in fact express to the defendant that it was not consensual. So it's more an argument in the abstract than it is that it actually affects real cases most of the time.
Yeah, because even in that situation, wouldn't you still fall back on, well, he was so threatening that I froze up because I was scared? Like, isn't usually the defendant doing something that would be causing the person to not?
That would be, excellent. I would definitely argue that as the prosecutor, for sure.
Or otherwise, like usually if you freeze like that, maybe you have a prior trauma, so like you can bring that up and say, hey, like, I have this trauma, that's why I froze, that's why I didn't do something.
Right, and in those cases, the whole issue that I sort of said we'll get to later about what do we want to require in terms of mens rea? Do we want to say that if the defendant honestly believed there was consent, that means that the defendant lacked the mens rea to commit the crime of non-consensual intercourse, that is rape, right? And if there's does that mens rea have to include at least knowledge of the non-consensual nature of the intercourse? And if it actually was non-consensual, and the defendant either honestly or reasonably mistakenly believed there was consent, does that negate mens rea? Remember what we talked about in mistake of fact? Under the attendant circumstances as the defendant believed them to be. And on your exercises, those of you who use that phrase a lot did better than those of you who ignored that phrase, I'll just tell you. But the attendant circumstances the defendant believed them to be. Apply that here. If the defendant believed that the attendant circumstances were that it was consensual, does that negate mens rea? Remember, the rule of mistake under the model penal code, or impossibility, is under the attendant circumstances as the defendant believed them to be. It would have been consensual. It can't even be an attempt in that case. And it certainly can't be the completed crime. If we apply that general rule, maybe there are good reasons, and we will talk about this, not to apply the general rule because of the unique nature of rape and the way the interaction of the defendant and the victim's perspectives. But we'll talk about that. Okay? We're a couple of cases behind, but we'll try to make that up as we move through. Is that right?
Yeah.
That's fall break? All right, I will see you next Wednesday. By next Wednesday, I will for sure have